Webinar has started.
All right. Well, while we let all this fill up, everybody in, and we'll actually kick it into gear. Richard, I know you are trying to help some charitable causes here, especially saving the lions.
Right.
I don't know if you'd mind kind of giving a little couple-minute explanation of the wonderfulness you're trying to do for this world.
Sure. I wasn't expecting to talk about this, but
welcome to the fire. Now we're just going to throw you right into the middle of it.
So, there's a problem in this country with captive exotic cats. So, people find these roadside zoos or, other events or places where they can like pet cubs or take photos with them or whatever, which is cool. Like cubs are really cute and it's really cool to like hold a baby tiger, a baby lion. The problem is that those cubs are only small and cute for 4 months or so. And by the time they get over 4 to 6 months, they become too big to really hold and pet and cuddle and have interact with the public. And they no longer are cute and therefore no longer profitable. And so these cats that have a 20-year lifespan get discarded before they're even a year old, and they're found malnourished, they're found abused, they're found neglected. A lot of them are euthanized, and they can't, unfortunately, be let back in the wild because they can't survive in the wild without having like been born and grown up there. They don't have those skills developed. So there's a glut of big cats all over the country from private owners, from these zoos or whatever. And the only real hope for them are sanctuaries. And these sanctuaries, are nonprofits, and they bring in these cubs. The one that I support is in Wiley, Texas. It's called InSync Exotics. And they have, depending on the day, 74, 75 big cats that they care for and give them a lifelong home and veterinary care and food. And if you can imagine that feeding a steak dinner to an 400-pound obligate carnivore every night is rather expensive, and getting a dentist to work on their teeth is rather expensive. So they need support and money to care for these cats for the 19 and a half years they have left after they've been discarded by these carnies. Ways that people can help: one, find a legitimate sanctuary, donate your time and your money to it, and two, don't participate in tiger and lion photo ops and cub petting and things like that. It's cool, but it's not cool. Stay away from it and don't support that industry. So there's my soapbox.
I know that you're asking for some donations, and you're even doing some matching, and there may be matching. Just kind of while I kind of kick off what we're going to talk about today, would you mind sharing in the chat just a little click or wherever somebody can go if they did want to actually help you out?
Sure. So the matching I do every year on North Texas Giving Day, which is already passed, but we raised with people donating on my page, and then my match, and then the donor that matched my match, we added $20,000 to the organization in one day. And overall, on North Texas Giving Day, they raised $180,000, which is great to help build new enclosures and take care of these cats. But you can, visit I don't have the website off the top of my head, but if you Google InSync Exotics, not in like the band, but InSync Exotics.
Let me do you a favor. Find it, throw it in the chat, Kim, or throw it in the chat. And I'm going to kick this off with kind of why we're here and talking about, your liabilities, or not your, Richard, but your audience. If you are managing an LLC, if you are raising capital, if you're doing investment deals, let's talk a little bit about the good, the bad, and the ugly, about really what your risk factors are. And please, 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 any questions that you may have, add it to the chat, add it to the question box. And once we're kind of talk high level through everything, we do want to take our time and really answer as many questions as humanly possible. And if you do ask a question and lunch is up, you got to jump, just shoot us an email. We'll make sure to still answer your question. Want to make sure that everybody is comfortable. And just to kind of kick things off, I want to tell an actual true unfortunate story of, this day that I was sitting in the office and I get a phone call from the SEC. And I got to tell you, like my heart skips about 5 beats, brain is like, what's going on now? Answer the phone, and the attorney says, hey, you know what? I just wanted to give you a heads up. Expect a subpoena. It's for one of your clients. And, that's never a fun thing to have happen. And I'll talk a little bit about how this ends up really an investigation or anything along those lines happens at the end. But I kind of wanted to tell you because ultimately this particular client that I'm not going to name names, but can talk in some specific generalities is today spending the rest of their life in jail. And I never, ever, ever want that to ever happen with any of our clients. And this is one that frankly just didn't do what I told them, their concerns and what they should be doing. But it's kind of the source of a lot of you, the audience, your concerns about, am I going to go to jail? And let me give you an example of when in fact somebody is spending the rest of their life in jail, and actually their entire team is spending decades to life in prison. And it goes back, decades, decade and a half at this point. And so I had this client, he was trying to create this opportunity for investors to come to the table. I informed them, what you're trying to do is a security. Here's all the securities regulations. Here's what we've got to do. Write a nice little memo, send it over to him. This particular client quit being a client, runs off, finds another franchise attorney that says, you know what, you can do this as a franchise. Don't worry about the securities laws. Don't worry about Nate. There's a better way to do it. And so they developed a passive franchise, did all the right things under the franchise laws, except it didn't change the fact that it met the test of the securities. Again, a passive franchise where they were just stacking businesses on top of one another, managed by somebody else, raising capital from a multitude of franchisees. Eventually, the state stepped in, stopped all operations there, started filing lawsuits. But that's not even why he ended up going to prison. That was subsequent to, they were still running the franchise, but I think they're seeing the writing on the wall. And so they had to move on to the next business. And oftentimes these serial entrepreneurs that may have a problem are moving on to the next opportunity before the proverbial stuff hits the fan. And so I get another phone call from this client. I don't know anything that's going on with their purported franchising. Says, now we're going to create this services-based company where we're going to get certain governmental communications rights. We're going to have to go through the development process. There's certain steps that have to happen. We're going to sell it to people, or they're going to pay us to go through the process on their behalf. And when they actually start making money from it, fantastic. They're going to make a ton of cash. I tell them again, hey, this is a security. You need to do a private placement for it. This time around, he says, great, let's go. We're on board. Go through the entire process, get everything set up legally for him, where he's ready to start bringing on investors. Now, this is where things get a little bit more difficult. He gets a legal opinion, a written opinion from this franchise attorney that has no idea anything about securities, a legal opinion saying, no, 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 you don't need to do a PPM. What you're doing is not a security. It's a services company or a JV company or whatever you want to call it. So this particular client, who really they end the client relationship at that point, throws the PPM away. I write them this lengthy, really, you got to watch out. You got to make sure you're doing things right. You got to stay protected. And then I never hear from them again until I get this call 6-7 years later, if not even longer, from the SEC. And love it. The SEC says, well, you know what? This particular person, their big defense of why they were doing things right, defensive counsel. Not my counsel. It was this other counsel that the other attorney that didn't even actually know or understand securities laws, gave this opinion saying that what you're doing is fine. As soon as their defense became, we were just relying on our attorneys, it waives the attorney-client privilege, meaning everything I ever told to this client, all of my communications, all of my emails, it was Pandora's box of problems when this guy's attorney is telling him at the time, you can't do this. You're going to have these issues. You cannot paint a picture like it's not a security. And now all of a sudden it's not a securities investment. So I actually ended up being a key witness in this one. Hate how it all kind of played out, but ultimately it wasn't just this client. It was this client's wife, best friend, the guys that were selling these services on his behalf. Every last one of them went to prison. And you know what? It could have been a whole lot easier. All they would have had to do is follow attorney advice. And so after we kind of go through a lot of the good, the bad, the ugly about kind of what your risk factors are and how to do it right and what to expect, the final words will always be follow attorney's advice. That's why we're here, is to keep you out of jail, keep you out of prison, keep you out of troubles. And that's our entire goal. So we'll talk about a few of the different subjects, such as what's your liabilities in the securities realm, what's your liabilities just the manager of an LLC, as well as going through an audit or investigation, kind of what to expect. I hate to say that I've gone through quite a few of them. And so really, we're just here to do what we can to provide you the information to protect you as much as possible. And with that, please let me introduce my partner and really the brains of the operation, Mr. Richard Robinette. And I'll just sit back and twiddle my thumbs for a few minutes.
I've got the brains, you've got the looks. Let's make lots of money.
Woohoo!
All right. I'm gonna kick this off. I'm gonna talk about liabilities, and I'm gonna talk in two areas: LLCs and then securities offerings. Let me start off by trying to limit my liability just a little bit and give you my mandatory legal disclaimer that this is not legal advice. This is educational only, and this is such a ridiculous oversimplification of the subject that you shouldn't take any of this seriously without first talking to an actual attorney under an actual retainer and paying them lots of money for their advice. So this is going to be very general. Also, the things I'm talking about vary not only from state to state, but often from court to court within the states. And so there's a lot of diversity of opinion about these subjects. So I'm really just here to give you a 10,000-foot view to give you an idea of the landscape, but you definitely need to talk to your own attorney about particulars of what you're trying to do in your particular situation where you are. So with that, put that in your pipe and smoke it. Let's start off super basic with Fiduciary duties. You probably heard this term, and what on earth is a fiduciary duty? And if you read, you ask around or whatever, you're going to get a dozen different opinions, but they all basically boil down to one thing. And that is, a fiduciary duty is an affirmative duty to act in the best interest of someone else. You are put in a position where your job is not to look after your own interest, but this other person's interest. Examples of people who have fiduciary duties, and none of these should be terribly controversial. Lawyers have fiduciary duties to their clients, doctors to their patients, accountants to their clients, trustees to their beneficiaries, executors to the heirs and the estate that they're representing, investment advisors to their clients. And one that maybe people might find alarming is employees often have a fiduciary duty to their employer. Kind of an interesting, almost reversal of the power dynamic on that one. But there are many, many cases where employees have been found to breach their fiduciary duties to their employers, usually in the realm of trade secrets or unfair competition or things like that. But so those are kind of common ones. We're going to talk about fiduciaries specifically in the realm of managing LLCs. This is also going to be similar for corporations, partnerships, things like that. What kind of flavors do these fiduciary duties have? So there's many different duties that might fall under fiduciary duties depending on who you are. But common ones would be a duty of care. That's to consider options that are available and exercise sound judgment. Loyalty, which is putting the beneficiary's interest above your own and not doing anything for personal gain at the expense of the beneficiary. Duty of good faith is really kind of combining those two. It's acting within the law, always for the best interest of the beneficiary. So you're just going to do everything above board. And these three are kind of the holy trinity of fiduciary duties. Anytime there's a fiduciary duty found, almost always these three show up. In addition, you might also find a duty of confidentiality, not only to keep sensitive information confidential, but also to refrain from using someone's confidential information to benefit yourself. Insider trading is kind of maybe one that might come to mind there. Duty of prudence, that is, depending on your position, exercising professional skill, highest level of professional skill in carrying out your duties. So the more educated, the more skilled you are, the higher the standard becomes. And then duty to disclose, relevant information that impacts your beneficiary or impacts your ability to serve in your fiduciary capacity. So these different combinations of these will be found in different situations. But these are kind of the basics that you'd expect to run in. Now, where do these come from? Sometimes they're actually written into the law. They're written down in statutes or in regulations by regulatory agencies. More often, however, they're kind of just referenced generally, and then the courts are left to kind of figure out what duties apply in particular situations. So we have a lot of court-made law as well regarding fiduciary duties. And then fiduciary duties come from principles of equity. And equity just really means like ideas of fairness. And so examples would be a situation where someone has a position of trust or confidence with regards to someone else, or a legal right to control, for instance, someone's investments or someone's money. And then someone who has insider knowledge about another may have a fiduciary duty to protect that. So this is kind of the landscape here. Let me get into specifically talking about LLCs. And so here's an LLC. An LLC is really just a container for some kind of business or investment, right? So we got an LLC. The LLC has a purpose to do some activities or own assets or make investments, you know, perform business, something. It's got a reason for existing. And then the LLC has members. And member, when we're talking about LLCs, really just means owners. I don't know why we call them members. Someone years and years ago came up with it, and that's just what we call them. So you have these individuals that own the LLC. They usually invest time or money or energy into it. That LLC uses that time, money, or energy to invest, to offer a service, offer goods, whatever. But these members also exercise control over this LLC. And so in this situation where it's just the members, we call them managing members. And as managing members, they often have fiduciary duties, not only to the company, but also to each other. And this is particularly true when someone perhaps controls a majority. So you might have a 51% managing member, and that will almost certainly have a fiduciary duty to the other members because they have that position of trust, they have that insider knowledge, they have that ability to control. So that's one area that we'll often see it. Now, in the investment world, we don't usually have this structure with managing members. We split the roles and we have a manager on one side and we have members on the other. And the members usually are just putting in money, and the manager is the one that's actually making all the decisions and entrusted to do all the things. So there's where the majority of the fiduciary duties are going to show. He's going to duty both to the LLC itself and to the other members. And notice this hits those 3 points of inequity of creating a fiduciary duty: special relationship, trust, legal right of control, insider information. Check, check, check. So this is a pretty clear-cut situation where you're going to find a fiduciary duty. Now, this is kind of weird because LLCs are limited liability companies, and we kind of think of them as tools for limiting our liability. And then all of a sudden, you got this attorney telling you, well, if you run an LLC, you're going to have all these fiduciary duties. And that's probably true. State by state, it's going to vary, court by court, et cetera, disclaim, whatever. But the good news is it doesn't have to necessarily be this way. The cool thing about LLCs is LLCs are extremely flexible, and they allow you to write an agreement, either a company agreement or operating agreement, that says, we don't want the default rules. We want this LLC to run this way, and we want the duties to look like this. That's not necessarily what's in the statute. So lesson number 1, if you form an LLC, don't just get on the Secretary of State's website, pay your $300 and form it. You need a company agreement that governs how this LLC is going to run according to your needs, not this one-size-fits-all thing created by the state. So let's talk about limiting our fiduciary duties in the LLC. Can you do it? Sometimes. I'd venture to say most of the time. So let me give you a comparison of a couple states. So in the free and independent Republic of Texas, the statute straight up says you can expand or restrict any duties, including fiduciary duties, in your company agreement. So we can take these fiduciary duties that I just pointed out and basically reduce them to nothing or near nothing in our company agreement. You're going to see operating agreements that say things, to the fullest extent allowed by law, or adding indemnity clauses that says, well, if the manager breaches it, he's going to be indemnified for it, right? So there's an example. Now, if we go to the other end of the spectrum, People's Republic of California, their LLC Act says an operating agreement shall not eliminate the duty of loyalty, duty of care, or any other fiduciary duty, with a handful of exceptions that are too much for this particular discussion. But again, varying state by state how much leeway we have to protect the managers within our LLCs. And there's ways of dealing with this too. You could form, entities in other states or whatever that just do business in California and whatnot. So again, talk to your attorney. That's going to be the theme of the day. Talk to your attorney. And then are there any other protections? Well, there is one that's really, really important, and it's called the business judgment rule. And the business judgment rule, while recognizing that there may be fiduciary duties, also tries to avoid outcome-based second guessing of business decisions. And the idea is we can't expect a manager to bat 1,000. They are not always going to make the best decisions every single time, and they can't be held liable every single time they mess up just because they messed up. You know, they're human, and we kind of recognize that. So what the business judgment rule does is it prevents challenges to business decisions that are made in good faith, that are made with reasonably prudent care, and with the reasonable belief that the decision was, at the time it was made, with the information they had at the time, was in the best interests of the LLC, or in the best interest of the beneficiary of the fiduciary duty. So if you can check these 3 boxes, and notice these kind of resemble the holy trinity of fiduciary duties. If you can check those 3 off and show that your decision was made in good faith with proper care, believing it to be in the best interest of the organization, even if it was a bad decision and you lost people a lot of money, the business judgment rule is going to prevent you from being held liable. Here's a quote from the Delaware Supreme Court that basically says the same thing. To rebut the business judgment rule, you've got to show that they breached one of the triads of their fiduciary duty: good faith, loyalty, or due care. All right, talking really fast, and take a breath, and let's roll on. So we had the Monopoly jail, cop guy at the beginning, and so a question might be coming up: am I gonna go to prison if I breach a fiduciary duty? Probably not, at least in the context of simply managing an LLC and failing to take good care. Now, if we get into the realm of other crimes, fraud, for instance, then maybe we see prison time. But merely not doing, a very good job managing, probably not going to end up in prison. Securities laws, on the other hand, may be a little different. So let me switch gears and go real quick through securities laws. In the United States securities laws, we've got 2, pillars of securities laws: the Securities Act of 1933 and the Securities Exchange Act of 1934. And these 2 laws basically give us 3 main requirements. One is registration of securities or an exemption therefrom, licensing to sell securities or exemption therefrom, and full disclosure. Disclose all the things to everyone. When in doubt, disclose. So registration, the Securities Act says all securities must be registered with the SEC, unethical state regulators, or qualify for an exemption, and goes on to say it is unlawful, notice that word, unlawful, to sell unregistered securities unless an exemption applies. Licensing, very, very similar. Anyone engaged in effecting transactions in securities, selling securities for the account of others. So in other words, you, Bob Smith, are not selling shares of Bob Smith. You're selling shares of a corporation or units of an LLC. So you're selling on the account of another. You must be registered with the SEC unless there's an exemption. And again, it is unlawful for an unlicensed broker to induce the purchase or sale of a security, again, unless an exemption applies. There are exemptions. We do advise our clients on how to avoid having to be licensed as a broker. But bottom line here, if you don't have that exemption and you're not licensed, it is against the law for you to sell securities. Okay, and then full disclosure, full honest disclosure. Connection with the purchase of a security, it's unlawful to employ any device, scheme, or artifice to defraud, to make any untrue statement of a material fact, which sounds to me a lot like defraud, to omit to state a material fact necessary to make other statements not misleading. So it's not only what you say, but also what you don't say. And then engage in any act, practice that appears to operate as a fraud or deceit. So a little bit redundant here, but you get the idea. This is a rule called Rule 10b-5 under the Exchange Act. Very similar in the Securities Act. It says the offer or sale of securities is unlawful. It's unlawful to employ any device, scheme, or artifice to defraud, to obtain money or property by means of an untrue statement, or any omission to state a material fact necessary, again, to make other statements not misleading. Mitch Hedberg had a great bit, where he said, I used to do drugs. I still do, but I used to too. So the omitting the I still do makes that first statement misleading. So if this were a security statement, you would need to add in I still do, even though you said I used to. And then engage in any transaction, practice, course of business which would operate as a fraud or deceit. So almost the same language in the Securities Act and the rules of the Securities Exchange Act here. Bottom line, be honest. Fully disclose what you're doing. Don't play hide the ball. Don't get sneaky. Very, very, very important. Okay. So you might be thinking though, like, what if I'm not the one selling the securities? What if I'm not an issuer? What if I'm not even involved? Can I get in trouble under the securities laws? Meet my friend Kim. And Kim, if you've been paying attention to the news, gotten a bit of hot water recently with the SEC. And she got on her Instagram and she posted this post right here. So this is not financial advice, but I just wanted to share what I was told about this Ethereum Max token. They burned 400 trillion tokens, literally half of the admin wallet, to give back to the community. Swipe up to join and check these people out. She's not selling us anything. She's saying all true statements. She's not being misleading, as far as I know. Assuming that they really did burn 400 trillion tokens, that's a true statement. But she still got in hot water for this. So what happened? Well, we just talked about section 17A. That was the previous quote that I put up on the screen. 17B says it's unlawful for any person to give publicity to or circulate an advertisement or communication, though not purporting to offer a security for sale, but that just describes the security without fully disclosing the receipt of consideration and the amount thereof. So it turns out Kim Kardashian received $250,000 for sending that Instagram post. And she nowhere in her post disclosed that she had received $250,000, and the SEC got wind of it and went after her. And now she's going to pay them upwards of $1.2 million, which I understand is chump change for Kim Kardashian. That's why they settled so quick, but still a hefty penalty for an Instagram and apparently innocent Instagram post. So there's that. Okay, so how risky are things really? Well, I mean, Kim stepped into it pretty good there. But what are your risks? What are your liabilities? Well, one, investors that are harmed by your securities violations are going to have a cause of action against you. They can sue you. They can collect damages. They can get rescission, which means you're going to return all the money that you received from them, all your ill-gotten gains plus interest. And other damages under the act. They have a private right of action. And even investors who were not harmed, but maybe you ticked them off, they can tattletale to the SEC, and the SEC can go after you and seek disgorgement. Again, returning all your ill-gotten gains. They can charge you penalties. So Kim not only has to give back the 250 grand, but she also has to pay this penalty. And then injunctive relief, where you are ordered not to sell securities, not to advertise. I think Kim is required for 3 years not to tweet about cryptocurrencies. So that's another one of the consequences. Talking about the SEC levied almost $4 billion in fines last year. That's a lot of money. And they're not just going after big operators. They're not just going after Kim Kardashian and Ripple and all the ones that you see on the headlines. They're also going after small operators. And the difference with small operators is they don't have the war chest to fight. Ripple has the funds to take the SEC to task and to really, battle with them. You and I probably don't. So we are low-hanging fruit as far as the SEC is concerned. And the SEC is taking action even absent investor losses or even absent other securities violations. And the penalties, like I said, fines, disgorgement, and a permanent ban on raising capital. This can also happen with state regulators too. So you could be banned from raising capital in a particular state, or you could be banned from raising capital nationwide. All right. But is anyone actually going to go to prison? Well, if Nate's introduction was any hint, yes, absolutely. People go to prison for violating securities laws. Now, first of all, we don't even need the securities laws to get you in prison in most cases. The DOJ can simply charge you with fraud, wire fraud, mail fraud, money laundering, conspiracy. There's even RICO cases regarding the sale of securities, et cetera, et cetera, et cetera. All kinds of ways they can tie you up there. But even in the securities laws themselves, there are criminal provisions. So for instance, the Securities Act, Section 24, says any person who willfully violates any of the provisions of this title shall upon conviction be fined not more than $10,000 or imprisoned not more than 5 years. That's longer than Conrad Murray got for killing Michael Jackson. So Kardashian realistically could have, at least if it was willful what she did, if the violation was willful, which probably wasn't in this case, she really was just ignorant to what she was allowed to do. But could have faced 5 years in prison. Securities Exchange Act, Section 32, has a similar provision, again, adding that element of willfulness. So if you accidentally do it, you're probably only facing civil fines. If you willfully do it, under the Exchange Act, upon conviction, you can be fined up to $5 million and imprisoned up to 20 years. Or both, just to add insult to injury. So serious consequences are potential if you violate these. Now, the DOJ has better things to do than to go after most run-of-the-mill investors. So they're probably going to target the more egregious, the more blatantly fraudulent than they are people that are just small time stepping in it. But these risks still hang over your head, and you just never know when you're going to be the itch they want to scratch. All right, so what should I do? Well, again, you need a securities attorney, not a run-of-the-mill attorney, not your uncle that does wills and trusts, a securities attorney with securities insurance. It's really expensive, so most attorneys don't carry it unless securities are really their thing. And I can't emphasize enough, the internet is not a securities attorney. Please hire one. I don't care if it's us. I'd love it to be us, but please hire a securities attorney before you start issuing or selling securities. And with that, I'm going to throw up our logo. I'm going to throw up our email address. I'm going to punt back to Nate to talk about audits, and then we'll do some Q&A.
Well, sounds good. I will try to not belabor this. I know we're going to be going a little bit over an hour, so I not only apologize for us going a little bit longer. For your benefit, we're going to make sure that we answer all the questions. But definitely wanted to talk a little bit about what to expect when you're expecting. Not pregnancy, but problems with regulators, with the SEC. Every state will have their own division that they may do their own audits or investigations. And I've gone through quite a few of them over the years. It happens, especially when projects go wrong. You know, I started my legal career with a law firm at my law firm in Las Vegas before really every real estate deal that I had represented went belly up in Las Vegas around that 2008 to 2010 timeframe. Went through a lot of investigations, and they always started the same way. Some investor is complaining. Generally, the investor that has lost money, they're looking to recoup. They may reach out to their financial advisor to complain, or to their attorney wanting to file a lawsuit. Both of those guys, their first step is always the same too. So now we've got the investor, their advisor, and their counsel all complaining everywhere. And it's generally to the state securities department, division, section, whatever it is, and every state has one, or the SEC. SEC tends to deal with the larger problems or larger concerns, $1 million plus. The state will deal with more localized issues or smaller infractions or concerns. But there's a complaint that will get filed, then it gets to some investigating attorney's desk or investigator's desk. And step one, and you kind of got the hint from what I went through and have gone through quite a few times, everybody gets a subpoena. They call it a subpoena dulcis tecum, and I'm probably saying that wrong. Feel free to correct me. And it's a document subpoena. And really kind of the first step, and this is for any investigation or audit, the investigative body wants to gather all the information they possibly can about not just this particular investment, but in fact, everything that you're doing with investors. And so that's kind of one of those one bag egg could spoil the bunch, because the investigators, they're never just looking at, oh, this one project had a problem. They're saying, I know that you're having one problem. What else are you doing? Because they're going to start opening up all kinds of cans of worms. So that is a really important reason why to keep all of your investors happy and do everything that you can to make sure that you're protecting them. It's your duty. And I have little kids. And so all I'm thinking about as Richard is talking is that little joke of like, they're doing their duty. But in any case, so first there's this subpoena. You provide to the regulators, not just the PPM, not just the bank statements and every communication that went to the investors. They're asking about other contracts. They're looking at the bank statements because they want to see, did you transfer money to anywhere else that you didn't disclose or you were not supposed to? One of the fastest ways to have securities issues, and I've seen this so many times, is when you have plenty of reserves in one investment, no reserves in another investment. Like, well, it just makes sense to make a loan from one to the other. Guess what? That's a massive misleading investors, potential securities fraud that I've seen as little of a penalty as, disgorge everything that you've received and pay a substantial fine, to a right of rescission to the investors that really you can basically go bankrupt if you start owing the investors millions of dollars that you can't afford. And I absolutely know a few of these guys that have ended up in jail over really just doing it egregiously. But so it starts out with this, with the subpoena, providing information. The regulators, they go through absolutely everything and all the other projects that you've been doing as well. Next step is they start doing depositions. You'll generally get a subpoena to go meet with the state or whoever the regulator is. They may start deposing not just the primary sponsor or the salesperson, but they may begin deposing investors, vendors, your grandma. Really, they want to talk to everybody because they're still information gathering. And then once they have every document and they feel confident that they have all the information that they would expect, that they've gone through the information gathering through these depositions, at that point, now the regulator has a real decision to make, and hundreds of hours into some investigation, that's where it really gets to be a big risk. They can easily just start filing lawsuits. And oftentimes they will file a lawsuit without any notice, just as a surprise, get you rattled, and then open up settlement discussions. And there's always, nobody wants to go through the pain and cost. Even the state doesn't want to go through the pain and the cost of going through a trial. So oftentimes, if it's a minor infraction or a minor issue, your attorney and the regulator should be able to negotiate and come to a good solution. But if they don't, you could end up going to court. Whether it is a civil court or a criminal court, really at the end of the day is based on the claims or problems that the regulators have uncovered. Now, the Securities Division, they would bring civil actions. That doesn't stop them from referring the case to the FBI or to local, actual criminal enforcement, district attorneys or whatnot, to pursue it as a criminal action. So long story short, we want to avoid this at all cost, which it's to maintain your duties, treat your investors like their family, and make sure you do what you can to protect them. Institute best practices with communications, even when things are not going as planned. Be transparent and be open with the investors. If you start, stealing from Peter to pay Paul, big problems. Doing things without disclosing or talking to the investors, big problems. But then it could start with that subpoena for information, depositions, and then you hit that risk of, am I going to get sued over all of this? So I started this webinar with kind of a discussion about, or the story about my ex-clients that ended up in prison. And I'm not going to name any names still, but I actually just had to look up the outcome of their case. And I know that there's more people that were involved with this action. There were actually multiple trials that occurred. And one guy that I really liked, he only got 90 years in prison. Another one of these clients that, didn't like him quite as much. Apparently neither did the court, because he got 200 years in prison. And this poor gentleman, he's in his 70s. He's never going to see the light of day again. So I just really want to bring this up to emphasize this is so unbelievably important. And if you were to work with crowdfunding lawyers, love it. Our major goal is to make sure that you know the best practices, understand the best practices, and we're there to help guide and inform. If it's not us, no problem. Make sure that whatever securities attorney that you're working with is providing that same level of guidance, which is kind of a problem when they're billing by the hour, because you don't really want to call with a problem because it's going to cost you. It's just really, really, it's so important. Sometimes you just have to suck it up, buttercup, pay the price, make sure that you're staying out of trouble at all times. And if you do have additional questions, please add them here. We're going to start answering questions. Also, if you have more questions or you aren't comfortable with asking them here, no problem. Reach out to us. Our contact information is on the screen there. And with that, Richard, well, we got a couple of questions here.
We do. All right. So this first one is about your story. And the question is, if the other attorney told the guy he could use a franchise format instead of the PPM format, why is that attorney not in jail instead of his client, since he was supposed to be giving legal advice.
Mm-hmm. I will tell you, in the franchise case, I didn't keep up with it. I don't know what happened to that franchise attorney. No clue. But I can tell you that one of the later individuals that is now in prison, his attorney actually is also in prison. And I'll tell you, one of the biggest mistakes they made, trying to be cute about avoiding securities laws. This attorney had some crazy concept of, it's not a security because we're doing an association. And so he sold all kinds of investors into joining these associations that the SEC completely pulled apart. And absolutely, their attorney went to prison. And I am well aware of at least a handful of attorneys that have also gone to prison for aiding and abetting in fraudulent schemes based on bad advice. But at the end of the day, this particular franchise client was on notice of the issues. He kind of forum shopped to find an attorney to give him the information that he wanted, but it didn't change the fact that he knew or should have known that he was violating the
So
rules.
well, I'll add to that, I see a lot of deals where people are trying to get around doing an offering. And I mean, it's silly. You're buying millions of dollars in real estate and you're trying to avoid 15 grand for, a basic securities offering. It's just silly. Just pay it. But I see these where, we're going to form an LLC and we're going to just make everyone a manager, everyone a managing member. And therefore, because they're all active in the business, it's not a security. Well, it doesn't take a genius to realize that, it doesn't take 30 people to buy and operate an apartment complex, right? Not all 30 of the people investing in your deal are active participants. There's no way. And I think a regulator or a court is going to see right through that and be like, no, you were really selling securities. There's maybe 4 or 5 guys that are running the deal and everybody else is really just a passive investor. But follow-up question to this, Nate. She says, I've been told all kinds of crazy things from different attorneys and IRS types, trying to get clear answers and all of them contradicting each other. How do we determine who is right when we get so many different answers to the same questions?
Well, first step, talk to the people that actually know. As an example, with crowdfunding lawyers, we only focus on, 1 or 2 things: securities and sometimes real estate. That's it. We stay up to date with all the laws. We're notified every time the SEC makes a change. We want to stay on the front edge of this information. Really important for our clients, for us to make sure that we're not causing issues. Again, securities and investments is so specialized that most of the attorneys that are running around talking about it don't really understand it. If they're a generalist, not only do they not understand it, they don't know the technicalities of it. They also don't have insurance that covers it because it's kind of a unique insurance coverage. So the best thing to do is work with the best, work with the guys that actually focus on this particular issue that you're facing and not everything under the sun.
Awesome. Julian asks, what about going to court? What if someone doesn't like how you operated and they want to sue?
People can always sue. That nothing changes that, other than to use, again, the best practices with communications and how you treat your investors. If you make them your enemies, there is always that risk of lawsuit. But even if there's a lawsuit, that doesn't mean you're liable. It does mean that you have to fight through the process to make sure that, well, you see it at the end of the day. And I have absolutely had clients that have done things pretty well doesn't change the fact that somebody's upset. And there's even investors that will invest for the purpose of creating problems. They have relationship with attorneys, and the attorneys get their share of it. And that's why when you get those random phone calls, hey, John, I heard you're doing this deal. You don't know me, but I got a bunch of cash. I just got it out of this other deal. I'm looking to do something. You mind letting me invest into your 506B? These things honestly, truly do happen. And Richard, I'm sure you've got some interesting saga stories yourself when it comes to these things.
I won't get into that, but I will say that I've been sued for all kinds of crazy stuff. Never lost, knock wood, but you know, anyone can sue you for anything. They can sue you because they don't like the way you look. Doesn't mean they're going to win, but they can start the process and give you some headaches. Now, as far as protecting yourself, like when you're running an LLC, again, operating agreement can do so much to protect the manager from these kinds of suits, to limit your liability, limit your duties even, and indemnify you in case there is a suit. And then also there's that business judgment rule we talked about, where as long as you kind of meet those minimum requirements, those minimum fiduciary requirements as a manager, the court is not going to let a suit go forward just because they didn't like the outcome of a decision you made.
Love it. I'm going to ask a question that Maureen posed, and just because it's simple, quick, easy, and we can answer and move on. Can a nonprofit set up a syndication? Richard?
I mean, in most cases, they wouldn't need to, because you're not investing in a nonprofit with an expectation of profits, right? We do syndications to invest to make profit. They can crowdfund, and it's not the kind of crowdfunding we talk about as crowdfunding lawyers, which is, you know, securities crowdfunding, but they can do, you know, fundraisers on the internet from the crowd and raise money that way. So they don't even need a syndication. They're not worried about securities laws because nobody's putting money in with an expectation of profits.
Long story short, Maureen, and I got the exact same question literally earlier this week. Go do some fundraising. We quite literally started with talking about Richard's fundraising and what he's done for wild animals. That was not a securities offering. Right. You're safe.
Oh, good. I mean, if I had defrauded Richard, if I had lied about the matching or whatever, then maybe I'd face some consequences, but not from a security standpoint.
All right. Well, I'll ask you the last question we have on the list from Michael. Could you give some best tips for new GPs and managing members in limiting fiduciary duties? A local Denver attorney referred to filing in Wyoming as an example as a harder way to sue. But what are investor perceptions if we form an entity somewhere else and not where the property is? That was a pretty compounded question.
Oh man, and there's so much that's all wrapped up in this. So Wyoming's awesome. Wyoming is one of the most business friendly, LLC friendly states. It's got benefits of not disclosing the names of the principals of the LLCs. It's got very favorable protection against lawsuits, especially lawsuits against the individuals who own the LLCs, so external attacks. And so Wyoming's great in that sense. Notice you mentioned a Denver attorney. So Colorado doesn't have the strongest LLC protections. They're a little bit weaker, especially on those outside attacks. And so there's a big advantage to forming in Wyoming as opposed to Colorado for that purpose. As far as fiduciary duties, I'm not actually terribly well versed with Colorado and how much they allow you to limit those. Wyoming is very generous on letting you limit them. It's very similar to Texas. You know, I have people in Texas call me all the time. Should I form in Wyoming? I heard this guy on YouTube tell me that Wyoming is great. I think Texas's protections are good enough that it's not necessary. It's fine, but I don't think it's as important as maybe if you were in California or New York, maybe Colorado. So there are advantages. If you form an entity out of state and then you own property in a different state, you will have to register as a foreign entity in that state, and that does bring you under a lot of the rules of that state. So there's some trade-off there too. Again, I would defer to a competent attorney in that state as far as what you should do and how you should structure your LLC. As far as investor perceptions, I've never heard of an issue where investors cared what state you were formed in. It's become so common to form in Delaware or Nevada or Wyoming that I think a lot of investors, especially experienced investors, just expect it. So I don't think there's anything negative as far as forming there. Maybe if you formed in Nevis or the Cook Islands, maybe they go, oh, this is kind of weird. I did see that movie with Antonio Banderas about that, and I don't think I want to invest there. But
yeah, I would like to just add something if you don't mind, and I apologize for cutting you off, but I think it's really important for people to know, if you're buying a property in Colorado, and even if you're using a Wyoming entity, you're doing business in Colorado, you're still subject to the Colorado laws. You have to file, or you're supposed to file, as a foreign entity doing business in the state of Colorado. So it does offer a little extra benefit, kind of. From the lender side, a lot of lenders actually demand entities be formed in Delaware. But no matter what, at the end of the day, if you're buying a property in Colorado, you're subject to the laws of Colorado.
Yeah. And again, the big advantage of Wyoming over other states is really that external attack. It's not if your LLC gets sued, it's if you get sued. You run over somebody with your car and they sue you and they want to collect your LLC interest to pay off that judgment. That's where Wyoming and Texas and Nevada and Delaware really are strong, and states like New York and Colorado and California are not so strong. And that's a different issue than fiduciary duties of managers. So.
Perfect. Well, Richard, do you have any final thoughts or comments that you'd like to make to everybody? Besides that, thank y'all for attending. Thank you so much.
Thank you all so much.